One of the innovations this year has been to apply a traffic light system to what we do. And I want to say a little bit about that and why we've done it. It's really to make it a little more user-friendly and reader-friendly. Red represents a subject which the Commission considers that the government or the Northern Ireland Executive or relevant public authorities have failed to tackle something, and it amounts to an ongoing violation or an abuse of human rights in Northern Ireland. The amber traffic light identifies an issue which we recognise needs action, but which falls short of a violation or an abuse of human rights. And in some cases, initial steps may already be being taken on the necessity to do something, and it may well be being acknowledged, but it really hasn't progressed sufficiently. Green identifies a subject that's been acknowledged as requiring action to protect human rights in Northern Ireland, and either an effective response has been provided, again by either the UK government, the Northern Ireland Executive or relevant public authorities, or alternatively a firm commitment has been made to deal with the issue and demonstrable action has been taken. I have to admit that the system is not perfect, but it's an important benchmark of progress. And in terms of this document, 5 issues have been marked red, 2 green, and 52 are amber. And the amber reflects a multitude of circumstances. Some areas start at amber and can never go red. So, for example, it frankly is desirable to follow the rest of the United Kingdom, for example, to introduce legislation to make gay marriage lawful, to outlaw age discrimination in respect of goods, facilities and services, and to introduce the Armed Forces Covenant in Northern Ireland. But the failure to do any of those things doesn't amount to a human rights violation. It doesn't start as red, it starts as orange or amber, and it can move to green. The amber categorization also covers everything from issues that are close to realization, which we are confident will turn green next year, and other areas that could be very straightforwardly realized, through to issues where progress is proving difficult, intractable, or limited, where an optimistic prognosis is difficult to foresee. And I say that as somebody who is an inveterate optimist. So if I can't find much optimism, it probably means there isn't much. So examples of the former, the camp, the things that frankly are moving very much in the right direction, include the introduction, for example, of a victim and witnesses charter, which the details of which reflect the Commission's advice that was given to the Department of Justice on including essential components of the definition of a victim in line with the UN Basic Principles on the treatment of the victims of crime. Much of the Criminal Justice Bill that's before the Assembly at the moment is positive. However, we think there are 1 or 2 opportunities there that are being squandered. And, for example, we think there's an opportunity to, for example, introduce domestic violence protection orders in line with England and Wales. They have been piloted and worked very well. The opportunity to set time limits, for example, in how long it takes to get from initial charging to the end of a trial, which is something that's been recommended by the Criminal Justice Inspectorate. We think the Justice Bill could have addressed that and started that process. And it was interesting to hear Mr. Justice Weir's comments yesterday in that issue. So I suppose what I might call important kind of improvements in terms of the Justice Bill, but as they say in homework for my grandsons, some work still to be done. Important areas there. There are other measures that we think are almost over the line. An important issue about children, for example, being imprisoned in Hyde Bank. The practice has ceased. That's very welcome. I think we'd like to see the Criminal Justice Children Northern Ireland Order amended to make it beyond peradventure that children will not be placed in adult prisons. It's simply putting then in legislative force what has been agreed in policy practice. That would be relatively easy to turn an amber light to green. And there are a number of other measures around juvenile justice issues. The reform of bail law, for example, so that children are only held on remand as a measure of absolute last resort, because many children that are held on remand do not go on to receive a custodial sentence. Ensuring appropriate access to educational facilities for children in custody through the Department of Education and transferring that responsibility from the Youth Justice Agency. There's a working group that's looking at that. It's cross-departmental. We'd like to see that come to fruition. That's another amber that could very easily be turned into a green. Staying on what I'll call a positive vein, the imprisonment for fine defaulters has diminished markedly following the 2013 judgment in Northern Ireland of McLaren, where it was held that imprisonment without a hearing was contrary to Article 6 of the Convention. That's now been remedied by the Magistrate Court's amendment rules, and that's welcome. Our view is that, again, prison is not the appropriate sanction for fine defaulting. The fact that we've now diminished the number of people in prison by 90%, we're nearly there and over the line. It's also a very good example for me of the value of the Convention, and that's something that obviously Dominic will touch on in due course. A draft racial equality strategy has emerged belatedly this year, published by OFM-DFM. The Commission is keen to see a much more action-oriented final version, and drawing on the Office of the Commission for Human Rights guidance on national action plans against racism, which was published by the High Commission this year. A draft mental capacity bill was also published in 2014. The bill is progressive. It has the potential to move Northern Ireland from the back marker in the 5,000-metre race to the front runner. That is, I think, a really seminal and important piece of legislation. There's still work to be done in dealing with mental capacity for children under 16 years of age. And the Commission has advised that the review of the current framework should be developed for children within a specific time frame that gives the issue the priority it deserves. And we as a Commission, I think, are very mindful that the UN Convention on the Rights of the Child Committee is almost certainly going to look at this issue during its next treaty examination in 2015. So, continuing in what for me is a remarkably positive vein, two areas which have been marked green this year. The first is the tackling of the indefinite retention and disclosure of data in the cases of police cautions. There was a case in the European Court of Human Rights around a police caution that was given for a child abduction in a family dispute case, and the lack of safeguards was held to be a violation of Article 8 of the Convention. It's the case of MM versus UK in 2012. An action plan to remedy the shortcomings, including a filtering system, a relevancy test, scope for use of discretion, and an independent monitor to review individual applications. All of that are now either in place or close to fruition and are very welcome, and that, I think, for the Commission justifies a green light. The Department of Health and Social Services and Public Safety have updated information to provide that those who want to adopt and couples will now include unmarried heterosexual couples, same-sex couples, and those in a civil partnership. That closes a particular loop following a Commission's earlier legal challenge to adoption issues. So far, so good. But I do have a kind of curmudgeonly reputation to preserve as an occasional purveyor of doom and gloom. So I do want to emphasise and reference then some of the other areas that the Commission has concerns about. The first is dealing with the past. and the need to deal with the past both comprehensively and effectively remains unresolved. There have been several external attempts to craft an agreement. The Chief Constable, the Police Ombudsman, and in recent legal judgment, the Lord Chief Justice have all placed on record the concerns that they have about either resources or processes around Article 2 investigation issues and the fact that they are not being dealt with promptly and effectively. The difficulties of meeting needs of victims and survivors is also well documented. It's not something I need to detain this very knowledgeable audience with. But these issues, it seems to me, are not just about the past, they also affect the future. The issue is intergenerational, and it can neither be parked nor swept under the carpet. I'm not going to offer, frankly, in this speech a ready answer. We know what the kind of issues are, but what I would do is wish both governments and the political parties well in trying to reach agreement in the current talks, because I think it's absolutely crucial for all of our futures and those of our children and grandchildren. The test of compensation in cases of miscarriages of justice, which requires now the wrongfully imprisoned person to prove his or her innocence in order to obtain compensation, raises real concerns for both the Commission and the Joint Committee on Human Rights as to whether this amounts to a disproportionate limitation on Article 14 of the International Covenant on Civil and Political Rights, and as well whether it might be contrary to Article 6 of the Convention and also the common law. The UN Human Rights Committee has raised the matter with the UK government in advance of its examination under the International Covenant of Civil and Political Rights, which is due in 2015, and we await without the outcome with considerable, again, interest. The age of criminal responsibility is, commencing at 10 years, remains for the Commission and others a running sore. The UNCAT Committee has called for the age to be raised, and the UN Committee on the Convention of the Rights of the Child has repeatedly set out that the legal systems which set the age of criminal responsibility below the age of 12 are in contravention of internationally accepted standards. And this issue will almost certainly again be revisited by the NIHRC Committee in October 2015. Finally, and given that the news has broken today, the issue of termination of pregnancy. The Commission has been involved in prolonged correspondence with the Department of Justice, advising on the need to legalise termination in very specific cases. In cases effectively of sexual crime, such as rape and incest, and also in cases of sexual malformation of the fetus. We've expressed concern about the continuing lack of revised guidance on the termination of pregnancy from DHSS PS as well. I'm very aware the Department of Justice has published a consultation document proposing to extend legal protection for termination in cases of lethal malformation, and also to seek views on what to do where a pregnancy has arisen as a result of a sexual crime. The Commission's view is that the current position is contrary to Articles 3, Article 8 and Article 14 of the Convention. And we are about to take a legal challenge on the failure to introduce legal protection in those specific and defined circumstances. And I expect the papers to be lodged by the end of the week, and then we will obviously see what happens from there. I know we may take some hit from people saying, well, there's a consultation document, and aren't you usurping kind of parliamentary democracy? My view is that our job as a commission is to promote and protect human rights. We are part of the wider democratic checks and balances, and we would be in dereliction of our statutory role, having tried all other ways to try and persuade and advise the department to no avail not to take an action on this particular issue. And I recognise that will be contentious in many quarters. So, the annual statement reflects both the depth and the breadth and the range of treaties and international obligations that have been signed up by the UK government. They are an important part of democratic accountability and governance, both domestically and internationally. And in my view, they bolster faith in parliamentary and other democratic institutions rather than in any way diminish such faith. And I know, again, that that'll be an issue that Dominic will touch on. I have one final observation before completing, and that's on a number of occasions recently, the Northern Ireland Executive hasn't actually responded to reporting mechanisms for international treaties. And that's due to issues that remain in dispute between the main two political parties. For me, that sends a very unfortunate signal, both kind of domestically and internationally, but interestingly as well, I think, especially because there are many areas where there are no dispute in terms of what the Northern Ireland Executive is doing in terms of international treaty obligations. And it would actually be better to report on those areas of agreement and to set out what remains in dispute than to not report at all. And it strikes me that one of the political difficulties locally is that where we have an agreement on issues politically, then it almost goes largely unnoticed and unremarked, while disputes are played out in the public domain in technicolor. And that provides a skewed view, I think, of a frankly much more nuanced political realities that we have today. And I'm not trying to undersell or hide the fact that there are some very important and fundamental political differences to be resolved. But that isn't the sole story. And I think this is part of the difficulty of not responding to treaties in ways about what is being done, as well as in the areas where there is agreement to be reached. So my plea to the Executive is to report on what's going on in Northern Ireland internationally and to take those responsibilities fully and seriously. So, in conclusion, I hope you find the document useful in whatever important role that you play in political and civic life. In my view, an annual benchmark of human rights and where progress has been made is really very important. It allows us to pause, take a breath, and look at where we have made progress, and I've outlined a number of issues where there is more work to be done. We would welcome feedback as a Commission on the statement, and I hope you find it useful. So thank you for that.